expire.
And you represent?
For the dependent.
No? Mr. Okeke?
Hello, my lord.
Mr.
Hello, my lord.
Okeke?
I'm here, my lord. Hello, my lord.
Mr. Okeke, which of the defendants do you represent?
Name Pharmaceuticals, Nigeria Limited.
No, this is not your matter, not Nemak Pharmaceutical. You're in 206-2008, right?
Yes, my lord.
No. This is 430-2017. Oliver, Aloede Oko Oliver and National Pension Commission.
Yes, my lord.
Get to yours, Mr. Okeke. Yes, please.
Respectfully, my lord.
Yes.
Olamide Ogundare.
Who do you represent?
Appearing with me, my lord, is MM Ekpenyong Oniru.
Yes.
We announce our appearance for the first defendant, National Pension Commission, my lord.
All right. Who appears for Idigbe pension, please?
Respectfully, my lord, Fisayo Eson.
Mr. Eson, how are you?
Well, my lord, happy New Year, my lord.
Happy New Year.
Struggling with my audio. We respectfully appear for the second defendant, my lord.
All right. Can you kindly mute your mics, gentlemen?
As you call,
please, this one.
Mute your mics, please. Can you mute your mic, please, gentlemen? The one with the ITEL A23.
Okay. Ife? How to mute?
No, what you're supposed to do, you're supposed to mute your mic.
I should use my mic.
Mute it. So we
I should mute it.
Yeah, so
Okay,
you don't interrupt it when the court is reading its decision.
Okay, I should mute it. I think it's muted.
Thank you. This is the court's decision. This suit was transferred from the Lagos Division of the Federal High Court to the Lagos Division of the National Industrial Court following an order of transfer by the Honorable Justice A. Ofaji, consequential to the first defendant's preliminary objection dated the 22nd of August 2016 and filed on the same date. Following the transfer of the suit and via an amended statement of facts dated and filed on the 13th of April 2018, the claimant sought the following reliefs jointly and severally against the defendants. 1. A declaration that Section 4 of the Pension Reform Act violates the claimant's right to housing guaranteed under Article 14 of the African Charter of Human and People's Rights Ratification and Enforcement Act, insofar as it does not provide for allow payment to the claimant of a lump sum or other substantial payment to enable him to provide housing for himself and for his family. B, a declaration that Section 4 of the Pension Reform Act violates the claimant's right to dignity of human person guaranteed under Section 34(1)(a) of the 1999 Constitution of the Federal Republic of Nigeria as amended, insofar as it does not pay or permit the claimant to receive a lump sum or other sum sufficient to enable him to provide housing for himself and his family. C, a declaration that Section 4 of the Pension Reform Act is null and void and of no effect whatsoever, insofar as it mandates or empowers the defendants to only make paltry monthly payments below the minimum wage to the claimant, which payments are insufficient to enable him maintain a decent standard of living and thus contravenes the claimant's right to life, protection from inhuman and degrading treatment, right to dignity of human person guaranteed by Section 33(1) and Section 34(1) A of the 1999 Constitution of the Federal Republic of Nigeria as amended. D, a declaration that the provisions of Section 4 of the Pension Reform Act is null and void and of no effect whatsoever, insofar as it mandates or empowers the defendants only to make paltry payments below the minimum wage to the claimant, which payments are insufficient to enable him maintain a decent standard of living or provide reasonable accommodation for himself, thus contravening the claimant's right to life, housing, dignity of human person, and protection from inhuman and degrading treatment, provided under Articles 4, 14, and 16 of the African Charter and other treaties and conventions to which Nigeria is a party. E, and other directing defendants to authorize, permit, and pay the claimant and pay the sum standing to the credit of the claimant over to him to enable the claimant provide housing for himself and his family. And further to or in the alternative, and other directing defendants to authorize, permit the payment of and pay the claimant his pension at a minimum rate of 18,000 naira only per month, or such other sum equivalent to the standard set for payment by employers to workers pursuant to the National Minimum Wage Act as amended from time to time. And G, declaration that the guidelines and regulations currently employed by the defendants in calculating the pension of the claimant are null and void and of no effect whatsoever, insofar as they neither result in monthly pension payments to enable the claimant provide a decent standard of living for himself, nor to minimum payments to the claimant equivalent to the standard of living stipulated for payments by employers to workers pursuant to the National Minimum Wage Act. H, the sum of 5,271,399.22 only being the value of investment of the pension benefits and severance allowances accruable to the claimant from the defendant, less monthly periodic pension payments to the claimant from April 2009 to January 2014 when this suit commenced, and I, payment of interest in the above sum to the claimant as follows: at the rate of 36.15% per annum from the commencement of this suit until judgment, and post-judgment interest at the same rate of 36.15% per annum until the total sum is paid to the claimant or liquidated. Now, I've summarized the proceedings at trial and a summary of the case before the court and the submissions of the first defendant and the second defendant in final address, as well as the submissions of counsel. Let's skip all that part and go to the decision portion, which is what actually is just the first decision, which is what you're interested in. There are so many other matters. Read out today. Now, this is the position. I've carefully considered the submissions of counsel and considered all the exhibits placed before the court. I've also considered the testimony of the witnesses. I'll address first the challenge to the admissibility of some of the exhibits admitted into evidence at trial. The first defendant had raised objections to admissibility of exhibit C5, C6, and C7, while the claimant raised objections to the admissibility of exhibit 2. I've carefully considered all the submissions for and against the admissibility of the exhibits referred to above. This court, by virtue of Section 12(2)(b) of the National Industrial Court Act 2006, is empowered from the provisions of to depart from the provisions of the Evidence Act in deserving cases. The intention of the framers of the law here is to ensure that matters are not bogged down by technicalities and stringent rules. What is of paramount importance is that matters are decided on their merit, and this court having a complete picture of the actual disputes between the parties. Therefore, pursuant to Section 12(2) of the NICA, which provides that, and I quote, the court may regulate its procedure and proceedings as it thinks fit, and B, be bound by the Evidence Act, but may depart from it in the interest of justice. I shall be departing from the provisions of the Evidence Act 2011 on the conditions of admissibility of the aforementioned Exhibit C5, C6, C7, and Exhibit 2. I also rely on the case of Victor Idigbe versus United Bank for Africa, unreported appeal number CA/IL/20/2021, delivered on the 14th day of April 2022 as authority for the exercise of this court's discretion. Exhibit C5, C6, C7, and C2 were properly admitted and will be considered in determination of the rights of the parties, and I so hope. Coming to the merits of the reliefs in the sought here, I must state from the onset that the reliefs here are bereft of any clarity and murky at best. The onus is always on the claimant to show that he's entitled to relief sought. Decisions of court are not based on sentiments or wishful thinking. Cogent and compelling evidence is the requirement of proof. The claimant has not placed any shred of evidence to show that the prayers he seeks here can be granted. The claimant placed heavy reliance on Section 33(1) and 34(1)(a) of the Constitution of the Federal Republic of Nigeria, 1999 as amended, Articles 4, 14, and 16 of the African Charter of Human and People's Rights, as well as the Minimum Wage Act. None of these aforementioned statutes prescribe an obligation on the defendants or the Pension Reform Act, either 2004 version or 2014 version, to provide the claimant the relief sought here. What the claimant ought to have shown was the duty or a responsibility on the part of the defendants to provide and protect the rights claimed here as imposed by the Constitution and demonstrate how they failed in any such duty, but he failed to do so. Without a shadow of a doubt, the claimant here is entitled to the right to life, dignity of the human person, and to be free from torture and also to housing. But the Constitution did not say that these rights were to be obtained via the contributory pension scheme operated by the first defendant, nor did the African Charter provide for same. In addition, it would be an absurd interpretation of the law to find that there was an obligation on the part of the defendants to pay the claimant the minimum wage. Again, the claimant seems confused about his status. In one breath, he argues that he's entitled to pension, and in the very next breath, he makes reference to the national minimum wage that is applicable to 7 employees. Not even the National Minimum Wage Act prescribes the payment of emoluments for the procurement of housing. The 18,000 naira the claimant seeks as his monthly pension has not also to be shown to be the prescribed amount for the attainment of housing and to be free from torture. I've also noted that the claimant seeks the release of his total contributions to him to enable him meet his accommodation needs. This will be patently illegal and would defeat the entire purpose of the pension scheme. In effect, the claimant seeks to exit the pension scheme. I ask the question here, would the purchase of the house as the claimant desires from the release of his total savings cater for his feeding, medical, and other sundry needs thereafter? Or will the claimant turn around and then sue for reckless release of the funds by defendants to him, contrary to Section 7(1) of the Pension Reform Act 2014? Here, blame must rest squarely on counsel to the claimant, who I presume should know better than to raise the hopes of the claimant in asking for reliefs that are patently and manifestly not grantable by this or any other court. Again, I ask, why didn't the claimant sue his employer while in service for this reliefs? Or did he not have a right to life and dignity and freedom from torture then? This suit is completely bereft of merit and abuse of the court's process and a waste of scarce judicial resources, a shot in the dark, speculative, and disingenuous. I accordingly refuse all the relief here for lack of proof and dismiss the claimant's case in its entirety. Judgment is entered accordingly. We will have a copy of this decision sometime next week.
As a court, please. You are most obliged, my lord.
All right, Tuesday, Wednesday. Now, who is counsel in Nimel Pharmaceutical, or just Oladipo Joshua Olalele and Nimel Pharmaceutical? That's 206-2018. That's the next judgment. Toluwani Adebi. Do we have counsel? Okay, that will be you. Right? Oladipo Joshua Olaleye and Nimel Pharmaceutical. Who is counseling the matter, please?
Respectfully, my lord.
Yes, please.
Fidelis Emeka Okeke, appearing with me is my learned friend, Idigbe Lawrence, or the defendant, Nemel Pharmaceutical Nigeria Limited.
Yes, please. Who appears for the claimant? There's no representation.
It appears they have not joined. It
That's
appears
fine.
they have not joined.
Well, court will proceed to deliver its decision. Now, this is the court's decision. The claimant filed this action on the 28th of March 2018, seeking the following release against the defendant. 1, a declaration that the unwholesome treatment and threat to life of the claimant by defendants, officers, or agents unlawful and unfair legal practice. 2, an order of payment of outstanding 2-month salary. 3, an order for the payment of his entitlement under the insurance scheme, his pension deductions, delivery of his tax deduction. 4, an order that the car on which the claimant had expended about 1.5 million naira for about 3 years on maintenance, documentation, etc., coupled with the credit card policy be relinquished to the claimant. And 5, an order for the payment of 500,000 naira as outstanding balance of what is supposed to be the claimant's salary, monthly salary of 900,000 naira per month after probation from the 12th December 2015 to 12th April 2018 applicable to those employed after him. An order for the payment of 4% of the invoice value in the sale of stocks to the Lagos State Central Medical Store Oshodi from 2017 to 2018 in accordance with the policy for staff marketing, and an order for the payment Gentlemen, can you still hear me?
Yes, my lord.
Yes. Yes. So an order for the payment of outstanding annual leave for 2016 and 2017 and general damages of 5 million naira for the trauma and agony suffered from the threat, unfair treatment, agonizing sacrifice to meet up unfair demand of target and other unfair labor practices meted out to the claimant, and the cost of this action as the court may decide.
Yes.
Mute your mics, gentlemen, please. I've summarized the proceedings of trial, the case before the court, and then the submissions of various counsels in their final addresses. I'll skip all those parts. You see them once you get a copy of the decision. Now, and I'll go straight to the court's decision. Now, having carefully considered the processes filed, the evidence standard, and the submissions of counsel, it is this court's considered opinion that the sole issue that arises for determination is whether or not the claimant is entitled to relief sought. He who asserts must prove. This much is elementary. It is the claimant here that clearly bears the burden of proving his entitlement to relief sought, and where applicable, how you arrive at the quantum of money claimed. Now, I will therefore address the relief serially. Relief 1 is for a declaratory order. Now, declaratory orders are not granted as a matter of course. The party seeking such a declaration must satisfy the court that he is entitled to such declaration. What the claimant needs to prove here is that the defendant meted out unwholesome treatment to the claimant as well as a threat to the claimant's life. Paragraph 6 of the claimant's deposition of 28th of March 2018 referred to an alleged unfair labor practice where the defendant forced his sales representatives to borrow money to pay for supplies made to customers. The defendant denied this. Yet, nothing further in proof of this averment. There is nothing further in proof of this averment in the claimant's paragraph 6 was placed before this court. It is the party who will fail if no evidence were adduced that bears the responsibility to place such evidence before the court. Now, in addition, the claimant in paragraph 9 of the same deposition made allusions to the defendant's working conditions as exploitative and slavery, which were never made part of the working conditions. Paragraph 16 also made reference to some incessant threats from some superior officers who were not named, nor were the threats specified. I've closely examined the entirety of the claimant's exhibits. I'm in agreement with the learned counsel to the defendant that the claimant furnished nothing by way of corroborative evidence to support his allegations as highlighted above, which brings me to Exhibit C10, as tendered by the claimant. On his face, it can be discerned that it's an email from one Charles Akaka with the email address akakacharles@yahoo.com to 5 individuals with the claimant listed as the 5th recipient. It is also copied to 2 other individuals. There was some writing on blue ink. There was some writing on blue ink on this email, and a portion of it was underlined. But the fact still remains, it is an email. Being an email and consequently a computer-generated document is subject to rules of admissibility as well as all other computer-generated documents as prescribed by Section 84 of the Evidence Act 2011. The claimant had made no effort to attach the prescribed certificate of identification to this email, nor the claimant in his examination in chief made any attempt to orally state the conditions for admissibility. It therefore fails the admissibility test and it will be discountenanced by the court in determining the rights of the parties and as a whole. This court and all other courts have the inherent powers to expunge or discountenance evidence wrongly admitted at the point of judgment writing. This court can so moto do so without the prompting of any of the parties. I've listed several authorities on this. Now, Relief 1 is therefore unproven and fails. It's hereby dismissed accordingly. Coming to Relief 2, the claimant seeks an order for the payment of 2 months' arrears of salary. Now, this is in the realm of special damages. What is required of proof of special damage that the person claiming should establish his entitlement to that type of special damage by credible evidence that will convince the judge that he is entitled to an award under that head. That is the evidence that must be of such quality that a reasonable tribunal would accept. See the cases of Guinness Nigeria and Emmanuel Nwoke. At the risk of sounding like a lecturer, this court expected better from counsel to the claimant and improve of this claim. How did the claimant receive his salary? If through the bank, then provide an account statement showing the months paid and the amounts outstanding. This was unfortunately done here. The claimant only made reference to the alleged unpaid salary in paragraph 17.1 of his deposition of 28th of March 2018 and therefore abandoned the issue. No evidence was placed in support of this relief, and therefore found it unproven and hereby dismissed relief 2. For relief 3, it must suffer the same fate as relief 2. What is the evidence here of the claimant's entitlement under the insurance scheme? What exactly is an insurance scheme, and what is the evidence of its existence and the claim? C1 and C2 do not refer to an insurance scheme. This court will not act on speculation as to its existence and as a whole. Similarly, the question must be asked as to whether or not the claimant had a pension fund administrator or whether or not any deductions or remittances were made. A pay slip or an RSA statement would have sufficed here. But again, this was not done. Same applies to the tax deductions as alleged by the claimant. Nothing here shows how much was deducted or if there were any deductions made at all. I must find there's no merit in this and consequently dismiss relief 3 as unproven. Relief 4, for relief 4, Exhibit C2 is quite clear. Under the heading car policy that provides for an official car for use by a defendant's representative. Contrary to the averment in paragraph 7 of the claimant's deposition of 28th of March 2018, it is the representative that is assigned the use of the official car that would deposit 10% of the car's value with the defendant. This payment is to be done either as a one-off or to be paid over 6 months. This deposit is said to be refundable. However, where the representative leaves before the end of the policy, the 10% deposit will either be used to repair the car where applicable or be refunded to the representative. This policy also provides that there will be a monthly depreciation of the car and the representative will be entitled to pay the balance of the car, which would be communicated to him by the defendant. At the end of the policy, the 10% deposit will be taken as the purchase price of the car. Further, Exhibit 1 states in Clause 2 that, and I quote, the aforementioned car is registered in the name of the employer and remains his bona fide property, end quote. Clause 10 of the same exhibit also provides that the employer should give the car to the employer at a minimal decided cost after 4 years of proper use, and the official car be given to the employee. Now, the claimant has not shown that he had worked for a defendant for 4 years, nor has he shown that he had either been advised by a defendant as to the minimum value of the car he was supposed to pay and that he had paid, or that the policy had come to an end which conferred upon him the right of ownership of the car. There's nothing in agreement between the parties that said the ownership would pass to the employer on the basis of money expended on repairs. That is not part of the agreement, and the parties are bound by the agreement and as a whole. This court will not go outside of the agreement between the parties here for failing, will not go outside of the agreement between the parties here for failing to show the fulfillment of any of the conditions enumerated above. I also find this relief is unproven and therefore face is hereby dismissed accordingly. Relief 5 must also suffer the same fate as claimant has not shown by cogent and credible evidence or any evidence at all that's entitled to the sum of 90,000 naira per annum. But it's the 90,000 naira salary. What document created the specific entitlement to this sum? Nothing shows who those employees that received the particular amount were and what were their peculiar circumstances. This relief is speculative at best and lacking in proof. The claimant ought to have shown the obligation to raise the salary to this particular amount, not just the promise to review salary after confirmation. This relief is not grantable and therefore dismissed. For relief 6, the claimant seeks the payment of 4% of the invoice value for the sale of stock to the Lagos Central Medical Store Oshodi between 2017 and 2018. This relief is premised on Exhibit C2, but requires the payment to be made. And from the wordings of Exhibit C2, this 4% of the invoice value is to be made as a credit note. The claimant, yet again, has not shown evidence of this supplies being made to Lagos State Medical Store, how much is paid for the supplies and what the 4% due to him was. No shred of evidence was led to this effect. I've noted that Exhibit C6 was tendered by a defendant into evidence, but this document was merely dumped on the court with no attempt to tie its content to specific pleadings and reliefs. The defendant was not obliged to prove the claimant's case for him, and this court will not descend into the arena of conflict to do the work of claimant counsel. To do the work the claimant counsel neglected to do, being unproven, the 6 is dismissed. Exhibit C1, which is the contract between the parties, don't make any provision for leave grants. The claimant here seeks an order for the payment of this grant. So on what basis would this grant be calculated and paid to the claimant? Since there is no yardstick or agreement between the parties on such payment, the minimum here has not been done by the claimant to entitle him to the grant of this relief, and therefore release him and dismiss relief 7 for payment of leave grant. With no wrongdoing established on the part of the defendant, I must refuse relief 8 is hereby dismissed accordingly, and on the whole and for the avoidance of that, the claimant case faces his entirety and hereby dismissed. Parties are to pay the respective false judgments and entered accordingly. Now you can pick it up on Wednesday in Lagos, please. Please give me a 1 minute, gentlemen. Let me check my internet connection. Thank you, gentlemen. Do we have counsel here for Hewlett Packard and Bukumi Seweji? 655-2016.
Yes, Your Lordship.
Yes. Who represents the council, please, in NSCN/LA/655/2016? Packard and Bukumi Seweji.
Yes, my lord, Fola Adekoya for the defendant.
Fola Adekoya, right?
Yes, my lord, for the defendant.
Yes, who represents the claimant? There's no representation for the claimant. Well, this is the court's decision. The claimant instituted this suit via a complaint filed on the 27th of October 2016 and by an amended statement of facts filed on the 6th of March 2018. The claimant seeks the following relief against the defendant. A declaration that the defendant is liable to the claimant in deceit, breach of trust, or fraudulent misrepresentation for his actions in relation to microcode's claims for unperformed support services and the claimant's payment thereof. B, a declaration that the defendant breached his fiduciary duty to the claimant and thereby made secret profits from his involvement and dealings with microcode in relation to the business of the claimant. C, an order directing the defendant to pay the claimant 98,531,847 naira, being the outstanding damages covered by the claimant on the account of the defendant's action in relation to microcode's claim for unperformed support services and the claimant's payment thereof. C, an order against the defendant for an account, full and restitution to the claimant for every profit and or benefits in cash and in kind, whether primary or secondary benefits that in need or derived from his involvement and or dealing with microcode in relation to the business of the claimant during the defendant's employment with the claimant. E, a declaration that the claimant is entitled to trace the sum of 4 million naira into and claim equitable title to any real property for which the transfer of 4 million naira was made to Lekki Gardens Estate Limited on the 9th of July 2013 from the account of microcode by and on behalf of the defendant. F, a declaration that the claimant is entitled to trace the sum of 107,531,847 naira into the hands of microcode and claim equitable title thereto, being the amount the defendant through microcode deceitfully procured the claimant to pay out on account of unperformed support services alleged to have been performed by microcode. G, a declaration that the claimant is entitled to trace into the hands of and recover from microcode through the defendant as his controlling mind and hand the full amount of 98,531,847 naira, being the outstanding damages suffered by the claimant on account of the defendant's actions in relation to microcode's claims for unperformed support services and the claimant's payments thereof. H, an order directing the defendant to pay to the claimant, including the resources of microcode, 98,531,847 naira, being the outstanding damages suffered by the claimant on account of the defendant's actions in relation to microcode's claims for the unperformed support services and the claimant's payments therefore. I, interest on the monies contemplated in E and H above at the rate of 21% per annum compounded from day to day on all sums actually found to be due to the claimant from the defendant from the time each sum is found to have become due to the claimant until the date of judgment, and thereafter at the rate of 18% per annum until final payment to the claimant. J, further to an alternative to I, interest compounded from day to day on all sums found to be due to the claimant at the prevailing commercial bank rate, lending rate enforced from time to time, the funds in issue rental rate from time to time. And then finally, an order directing the defendant to pay the claimant the sum of 10 million naira being the cost of this action. I summarize the proceedings at trial and the submissions of counsel in final address. And go through to the Constitution Council, please. And the reply on point of law is the Constitution. I'll first resolve the challenge raised by the counsel to the defendant to the court's jurisdiction to pronounce on matters relating to the commission of crime. Counsel to the claimant, counsel to the defendant apparently did not avert his mind to section 254C5 of the 1999 Constitution as amended, which provides thus: the National Industrial Court shall have an exercise jurisdiction and powers in criminal causes and matters arising from any cause or matter of which jurisdiction is conferred on the National Industrial Court by this section or any other act of the National Assembly or by any other law, end quote. While this suit is not one filed pursuant to the above provisions, it cannot be correct for counsel to submit that this court does not have a criminal jurisdiction. In this particular suit, and indeed any other suit properly filed before this court has the powers to pronounce upon any element of the suit that borders on its criminal jurisdiction and as a whole, and therefore overrule the claimant's counsel's objection on this. The learned counsel to the claimant also raised a challenge to the admissibility of Exhibit C6 and DD1 tendered by the claimant on the grounds that this court cannot leave the corporate veil of companies. While not providing any authority to back up the submission, defendant counsel again needs to avert his mind to the principles governing admissibility of evidence by a court. Exhibit C6 and D1 are relevant and indeed critical in determining the issues in dispute between the parties and relevance to the test of admissibility. In the circumstances of this case, where the allegation is centered around microcode and compute code have been raised, it is in the interest of the parties that all issues are resolved fully. This court is closer with the jurisdiction notwithstanding anything else even contained in the Constitution to inquire into any cause or matter relating to or connected with any employment or labor matter. The dispute between the parties here centers on the issue that arose in the course of the defendant's employment with the claimant and the alleged use of vendors by the defendant in the breach of the fiduciary duty owed the claimant. These exhibits are admissible and are so whole. That is Exhibit C6 and DD1. Admissible and so whole. They were properly admitted and will be considered in the resolution of the issues between the parties. Now, the claimant here has shown that the defendant had received the sum of 16.7 million naira from Microcode's bank account. There was a feeble attempt at explaining these payments made to the defendant, who claimed they were for procurement of original spares to enable Microcode properly execute the contract the claimant had awarded it. This explanation is simply ludicrous. Is the claimant a supplier for Microcode? Why didn't the claimant refer Microcode to the supplier of these spares? What is the evidence that this 16.7 million naira went out to known and verifiable suppliers of spares or even back to the claimant? By his own admission, the defendant identifies the vendor to carry out the contract for the claimant and notifies it to submit a quotation for the work. He makes the recommendations and sends it for approval. This is where the abuse of the defendant is abuse of office. But the defendant is evident. If the defendant had to step in to procure original spares for Microcode to prevent the claimant from incurring financial loss, then Microcode was not competent and it can only be inferred that the defendant used his position to channel jobs to Microcode for his own benefit. The defendant also failed to substantiate his assertion that the money paid to his account was for this procurement. No evidence of this alleged procurement was placed before the court, neither the defendant showed cause. Neither the defendant caused Microcode to corroborate his fantastic story. Rather, the defendant expended so much time and energy to trying to stop this court from unveiling the promoters of Microcode. It has been shown before this court that the promoters of microcode and the defendant are comfortable bedfellows, and they seem to have a symbiotic relationship. The defendant sends contracts to microcode by using his insider privileges and position, while microcode pays the defendant off as evidenced by the defendant's own account statement. Exhibit C30 is critical here. It shows the payment of the sum of 4 million naira by microcode to Lekki Gardens Estate Limited, with the description that the payment was for, quote, WRT offer Siweje Bokumi, end quote. The questions here are, why was microcode making payments to a real estate company on behalf of the defendant? Was it a bribe given to the defendant? Was it a bribe given that the defendant could send contracts the way of microcode, or was it a kickback from the contracts awarded to microcode? As part of the bundle of documents admitted at Exhibit 31, there was a printer as part of the messages recovered from the claimant's phone, which reads thus, and I quote, "Hello, Sister Tosin. Please, if you receive a call from HP regarding the company called Microcode, or that they want to talk to Uncle Sonia, please tell them to call back in 20 minutes. Kindly call me immediately after so we can discuss. Please don't forget, because I used your number and Uncle Sonia's number as contact. I'm currently not in Nigeria, but my phone is available. Thanks, Ukumi," end quote. This shows microcode was just a conduit used by the defendant to procure contracts for his own benefits. No court would accept any justification for this message from a person obliged to protect the claimant's interest. The defendant was in continuous breach of this fiduciary duty, and I so hope. I am satisfied that the above was the true state of affairs, as the defendant was in a position to influence the selection of microcode by virtue of his position for the contracts. It is secondary that the defendant did not single-handedly authorize payments to microcode. He knew the system at the claimant company and he exploited it to his benefit, contrary to the claimant's handbook, thereby questioning a breach of the fiduciary duty the defendant owed the claimant, and so hope. In addition, Exhibit C4, which is the claimant's conflict of interest policy, provides on page 1 under the heading policy that, and I quote, "You must not engage in any outside employment or activities that will improperly influence your judgment, decisions, or actions in your role at HP. To assess whether a conflict of interest may exist, you need to consider all outside activities in which you may be involved, regardless of whether your role in the activity is called an employee, consultant, contractor, owner, investor, or volunteer," end quote. Now, Exhibit C6 shows that the two directors of microcode, while Exhibit DD1 shows the 3 directors of CompuCode. The claimant is a director of CompuCode, while Kumiyi Folakemi of number 11 Alaji Bakari Street, Agungi Lekki, and Adewole Olusanya of 18B Akede Street, Bashorun, Ibadan, are the directors of both microcode and CompuCode. Same names, same addresses were used in the CAC Form 07 for both CompuCode and microcode. This court does not believe in coincidences, but can draw the safe inference that the defendant simply used microcode to try and beat the claimant system and profit from it and as a whole. Exhibit C4 also provides under the heading personal benefit or gain from HP business, particularly the commission clause that, and I quote, "You may not receive any commissions or any other form of payment from HP business partners in connection with HP business transactions, except as approved in writing by your vice president in connection with joint marketing programs or the like," end quote. While under the family and relationship head, Exhibit C4 also provides, and I quote, "Appearance of impropriety. You must disclose in writing to your vice president any situation that involves a family member or anyone with whom you have a close personal relationship that could cause the perception of any conflict between HP responsibilities and your involvement in the relationship," end quote. Exhibit C4 also provides further that serving as a director of any other entity while employed by a claimant prohibits serving as a director of any other entity while employed with the claimant unless such an employee complies with the HP policy on service by HP employees as a director or officer of a non-HP company. All the foregoing shows the blatant and multiple breaches of the fiduciary duty the claimant owed the claimant by the defendant. In the circumstances, I find the claimant had proved its case in the terms of the relief sought here. The claimant had provided by overwhelming evidence the breach of the fiduciary duty, the fraudulent misrepresentation, and the breach of trust by the defendant. I am satisfied that the documentary evidence placed before the court, claimant shows his entitlement to the monetary claims claimed by it. Therefore, leaves A, B, C, D, E, F, G, and H all succeed and order as paid. Also award the sum of 1 million naira as cost of action in favor of the claimant to be paid by a defendant. The defendant's 30 days to pay all the monetary award here, failing which they will attack 20% simple interest until liquidated, judgment entered accordingly. Can pick up in Lagos on Wednesday, please. Now, who is counsel in 476-2018? Mr. Babatunde Aino versus Ives Medicare and Dr. Babatunde Okewale.
Good afternoon, my lord.
Good afternoon.
Barrister Adeyemi for the claim, my lord.
Barrister Adeyemi. Adeyemi.
Yes, my lord.
What is your full name, Barrister?
Christiana Adesola Adeyemi.
C.A. Adeyemi.
Yes, my lord.
You don't need to use the appellation, Barrister.
C.A. Adeyemi, my lord.
Who do you represent?
The claimant, my lord. The claimant.
Claimant. Yeah. Who represents the defendant, please? There's no representation for the defendant. Now, this is the court's decision.
With the greater respect, sir.
Yes, please.
Ambrose Obi for the defendants.
Ambrose Obi for the defendants, right? Now, this is the court's decision. The claimant commenced the suit on the 19th of September, on the 19th of September 2018, seeking the following reliefs against the defendant. One, declaration that the first and second defendants wrongfully and unlawfully terminated the appointment of the claimant. Two, a declaration that the claimant is entitled to the sum of 2,100,000 naira only being and pay salaries for 3 months in lieu of notice. That is from August 2017 to October 2017. And three, an order of this honorable court granting interest on the total sum of 2,100,000 naira only at the rate of 24% per annum, or at the central bank rate prevailing rate from November 2017 until the date of judgment in this action, and thereafter the rate of 10% per annum until the judgment sum is finally liquidated. And four, an order of this honorable court directing the defendants to write a letter of unreserved apology to the claimant. Five, an order of this honorable court awarding the sum of 8,750,000 naira being special or general damages for the wrongful and unlawful termination of some. Mute your mic, gentlemen. And six, an order of this honorable court directing the first and second defendants to pay the claimant 10% commission generated during the claimant's period of employment in the first defendant's company. The defendant entered appearance and counterclaimed against the claimant. Defendant to the counterclaim and sought the following reliefs: an order for the repayment of the salary of the month of July 2017, the sum of 600,000 naira, and B, an order for the payment of 1,800,000 naira being 3 months salary in lieu of notice, and C, an order for the payment of 1 million naira being solicitor's fees or cost and damages in the of 8,750,000 naira for his resignation without due notice. Summarize the case before the court on proceedings and trial, and to summarize the submissions of counsel, and going straight to the court's decision. Now, in this court's considered opinion, the issue that arises for determination is whether or not the claimant is entitled to relief sought. Determining this issue would, as a necessary consequence, also resolve issues in the counterclaim. There are certain facts that are not in dispute here. The parties are idem that the claimant was employed by a defendant as managing director. Parties are also agreed that defendants, by a letter dated 30th of June 2017, terminated the claimant's employment. See Exhibit C6. This termination was to take effect from the 31st of July 2017. The endorsement on Exhibit C6 shows the claimant will receive the letter on the 11th of July 2017. The parties have markedly different differing versions of events that followed the issuance of the termination letter. While the parties are agreed that the claimant subsequently wrote a letter resigning his appointment with the defendant, see Exhibit D3, which is dated 12th of July 2017. I beg your pardon. While the claimants are markedly different versions of events that followed the issuance of the termination letter, while the parties are agreed that the claimant subsequently wrote a letter resigning his appointment with the defendant, see Exhibit D3, which is dated 12th of July, the stamp on this document shows the the received stamp. The date on the received stamp of this document also shows the 12th of July 2017. Now, this situation raises several questions. The claimant resigned a day after being informed that his employment would be terminated on effective the 31st day of July 2017. While the defendant contends that the claimant had pleaded that the termination letter be withdrawn so the claimant could resign, the claimant counters this and insists that he never pleaded for Exhibit C6 to be withdrawn. Rather, the claimant's position is that he tendered his resignation due to the shock of being served with Exhibit C6. As at the 12th of July 2017, could the claimant still resign from the defendant's employment? The answer here is in the affirmative. I find here that the claimant was still in the employment of the defendant until the 31st of July 2017, as Exhibit C6 will only become effective on that date. The claimant was entitled to resign then and as a whole. Was entitled to resign and as a whole. Exhibit C1 in the termination of employment clause provides for either party to terminate the employment contract by giving 3 months notice to the other party or pay the corresponding salary in lieu of notice. In this course considered opinion, the act that must necessarily crystallize to confer upon the claimant a course of action will only be complete on the 31st of July 2017, where upon the exit of the claimant, the defendant failed to comply with the payment of the salary in lieu of notice alternative as provided by Exhibit C1. Exhibit C1 forms the contract between the parties and the parties are bound by the terms. Given this scenario, I find that it is the claimant who was obliged to comply with the termination clause of Exhibit C1. The payment of the 3 month salary in lieu of notice was binding on the claimant and became due on the 31st of July 2017 and as a whole. I've considered the fact that both Exhibit C6 and D3 were to come effect on the 31st of July 2017. I earlier stated that there were questions surrounding the events leading up to the resignation of the claimant. Civil cases are decided on the balance of probabilities. The defendant's versions of events is certainly more credible and believable. It simply defies logic for the claimant to attribute the writing of Exhibit D3 to shock when the defendant had offered a more coherent explanation that the claimant wanted to resign. If this was not the scenario, the claimant could have simply waited for 31st of July 2017 and still exit the defendant's services. But under his own hand and with no evidence of compulsion, the claimant decided to resign even before the termination became effective. He had the right to resign, and the defendant had no discretion as to whether to accept or not. A resignation letter becomes effective once received by the employer, subject only to any stipulations as to notice. Whereas in this case, the employee opted not to comply with the requirements of notice or payment in lieu, the only option available to the employer is to sue for what it would have been entitled to under the notice period. I've therefore come to the irresistible conclusion that the claimant here, in the exercise of his rights under Exhibit C1, could resign before the 31st of July 2017. The claimant's course of action had not arisen as at the 12th of July when he resigned, as he could have waited for the 31st of July 2017 to see if the defendant would pay in the 3 months notice in lieu of notice. And by Exhibit D3, the claimant absolved the defendant of the need to make this payment. Rather, it is the claimant that was obliged to pay the 3 months notice and so forth. The claimant here also seeks an order for the payment of 10% commission as per his contract. But all the claimant put before the court is a document that is of dubious origin. It has no markings to show it came from the defendant's computer system, and no supporting correspondence to show the claimant actually attracted the patronage he insists he did at that material time. This is also unproven and consequently dismissed. I therefore find no merit in the claimant's case and hereby dismiss in its entirety. Judgment entered accordingly. I would adopt my findings. Now, coming to the counterclaim, I hereby adopt my findings and conclusions in the main suit. I find the counterclaimant is entitled to the payment of 3 months salary in lieu of notice to be paid by defendant to the counterclaimant to be paid by defendant to the counterclaim as specified under the employment contract that is Exhibit C1. Relief B of the counterclaim hereby succeeds and is hereby ordered as paid. However, all other reviews in the counterclaim are unproven. I find on the evidence before this court that defendant to the counterclaim is entitled to his July 2017 salary, and I refuse Relief A of the counterclaim. Relief D of the counterclaim is also without merits and hereby dismissed. Same parties are to bear the respective costs. Judgment is entered accordingly. You can pick up, please, in Lagos on Wednesday.
As cooperative, my lord. Straightforward.
Now, for Oluwa Seun Adeyemi and First Marina Trust.
We don't win. The director where we sack.
Yes, who is casting Oluwa Seun Adeyemi? And First Marina Trust. Mr. Oluseun Adeni Awonuga and Mr. Olaleka Badejon, they're not with us. All right, this is the court's decision. The claimant commenced this suit on the 5th of February 2018 via the general form of complaint and statement of facts. The claimant claims against the defendant as follows. One, the declaration that owing to the defendant's failure to conduct an investigation as stipulated in the defendant's letter dated 19th of September 2016, the purported suspension of the claimant without pay is void, illegal, and a gross breach of contract of employment between the defendant and the claimant. B, an order setting aside the defendant's letter dated 19th September that purported to suspend the claimant without pay. C, a declaration that the purported suspension of the claimant without pay is void, illegal, and a gross breach of contract between the employment. A declaration that the defendant's indefinite and continuous suspension of the claimant is unreasonable, unfair, amounts to self-help, and is inconsistent with the fundamental principles of natural justice, and thereby consequently invalid, null, void, and thereby of no consequence, of no effect whatsoever. E, a declaration that the defendant owes the claimant salaries, wages from September 2016 to November 2017, and F, mute your mics, please, gentlemen. F, an order that the defendant pays the claimant the sum of 6,136,865 naira, representing the claimant's wages or salaries from September 2016 to November 2017, and G, a declaration that the defendant has caused the claimant pain, trauma, suffering, and personal injury. And H, an order that the defendant pays the claimant the sum of 500 million naira as general damages for pain, trauma, suffering, as well as personal injury the defendant had caused the claimant. I, an order the defendant pays the claimant all other outstanding emoluments and benefits entitled to. J, an order that the defendant remits all the claimant's outstanding pension benefits to the claimant's nominated pension fund administrator. K, an order directing the defendant to pay the claimant the sum of 5 million naira being the cost of this action. 10, post-judgment interest, 10% post-judgment interest on all sums awarded by the court from the date of judgment until the date of final liquidation, and consequential orders this court may deem fit to make on the circumstances. Summarize the case before the court and commissions of all counsel and the institute reports to please counsel. This is the constitution. Having carefully considered the counsel, before the court, I will start off with the resolution of the preliminary issue raised by the claimant in his final address. Learned counsel to the claimant had contended in the main that it amounted to an abuse of the court process to raise the issue of whether or not the claimant is not caught up by the issue of res judicata. I've considered the arguments proffered by both counsel on this issue. I must admit some perplexity at the claimant's counsel's position. Like the defendant counsel rightly pointed out in his reply to the claimant's final address, the motion of 3/3/2022 was never pronounced upon by the court. On the 18th of October 2021, prior to the adoption of the respective final addresses, the learned counsel to the defendant, Mr. Badejon, informed the court that the defendant had an application he filed on the 3/3/2022. Counsel withdrew same and urged the court to strike it out. With no opposition from the claimant counsel, the court granted the defendant's counsel's prayer and struck out the application of 3/3/22. This simply means the defendant was entitled, as he did, to argue his position on whether or not the claimant was caught up by res judicata in his final address and so home, which brings me to the merit of issue 2 as formulated to the defendant as to whether or not the claimant to this border on his arrest and incarceration by the police and the FCC at the behest of the defendant amounted to breach of his right as to entitle him to damages. Now, the defendant had made reference to an exhibit attached to the application of 3/3/22, which exhibits the judgment of the High Court of Lagos State Quorum Onibajo J, delivered on 11th of June 2020. The issue is that the application alongside the exhibit attached to it were withdrawn by the defendant and accordingly struck out. The defendant, however, supplied the court with certified true copies of the originating process and the court judgment in suit number LD/8097MFHR/2019. I've carefully considered the said CTCs. I must immediately make the point here that this court cannot review the judgment in the said suit LD/8097MFHR/2019. I find, however, the defendant was right to draw this court's attention to the judgment of 11/6/2020. Further, I agree that the learned counsel defendant that part of the review sought in this instance suit cannot be re-litigated upon by the same parties based on the same set of facts and grounded on the same evidence. His Lordship Onibanjo J had held thus at page 4 on paragraph 2 of the judgment that, and I'm quoting His Lordship now, the foregoing being the case, and because from the affidavit evidence adduced to the court by the claimant, all the defendant appears to have done is merely discharge his duty as a citizen by laying criminal complaints to law enforcement agents against the claimant and others due to the alleged fraudulent conduct at the time of the employment by the defendant. I find no merit in this suit, and I shall dismiss same without more, since it is clear to me that defense actions complained about by the claimant in this suit do not amount to the infringement of claimant's fundamental rights under these circumstances. See the case of Sonny Obochi versus Godwin Ekpo and others, citation provided, where the Court of Appeal quoted a Supreme Court decision in Faji Mereokun versus Commercial Bank as follows: that generally it is the duty of citizens of this country to report cases of commission of crime to the police for their investigation, and what happens after such report is entirely the responsibility of the police. The citizen cannot be held culpable for doing their civil duty unless it is shown that it is done malified, end quote. The claimant's instance reliefs G and H have effectively been covered by the doctrine of res judicata here. If there's any abuse of the court process, it is on the part of the claimant who files separate suits before two courts of coordinate jurisdiction, seeking what was in effect the same reliefs as part of the larger claim. This invitation to anarchy must be deprecated in the strongest possible terms, as it is the same parties and counsel that will shout to the high heavens where conflicting decisions are given on this same set of facts and evidence. I therefore dismiss relief G and H on the grounds stated supra. Coming to the crux of the claimant case, the parties had idem here that there existed an employee-employee relationship between the parties. It's also settled that there was an incident involving the fraudulent withdrawal of the defendant's client's funds in which the claimant was implicated, reported to the police, and subsequently suspended. A careful examination of the timeline of events leading to the suspension of the claimant is critical here. It is not in dispute that the fraud was discovered on a Friday by the defendant, which initiated an inquiry into the circumstance leading up to the fraudulent withdrawal. The defendant made a report to the police, which is the body statutorily empowered to investigate crimes of this nature. The claimant, alongside the other employees, were detained by the police in the furtherance of the investigation on Saturday. By Monday, the defendant took the decision to and proceeded to suspend the claimant. Now, the claimant argues that the power to suspend was not part of the employment contract between the parties, that this rendered the suspension negatory and void. Ordinarily, this may be correct. However, the question before the court is whether or not the defendant being the employer here retains the inherent right to suspend an erring employee whose alleged conduct is of a serious nature as to warrant an investigation by the police. It is my considered opinion that the defendant here does have that right within the confines of these circumstances. No contract can legislate for any and all possible scenarios or situations. Where these scenarios or situations arise, recourse must be had to what is justifiable steps in the protection and the interest of the aggrieved party, here the employer. It seems to me that it would be an aberration for the defendant to permit the claimant to continue to perform the same duties that led to the alleged conduct complained of while investigation continues. An employer has the right to suspend pending investigation, especially of a serious nature that affects the trust or confidence between the parties. This the defendant did here and cannot fault it, especially where the claimant himself admitted seemingly under his own violation to receiving payments from the participants criminals of the crime, that is the Bureau de Change operator. To further buttress this point, the investigative agencies whom the report was made decided there existed sufficient grounds for the prosecution of the claimant and proceeded against him, and therefore satisfied that the claimant cannot hide under the guise of a lack of an explicit term to avoid the consequences of his actions. As a corollary, there is no explicit term in the employment contract that forbids the conduct allegedly committed by the claimant. These are terms that must be implied into the contract and are so whole. at his lordship Afen JCA held in City Central Group of Companies Limited by Mr. Dominic Eze, and report appeal number CS/A/108/2017 delivered on the 27th of September 2021, and I quote, the right to suspend an employee when necessary, either as a punishment or to enable investigation of an infraction, is an integral part of the employer's right to discipline his staff, end quote. Further, in the Bureau vs. Council Federal Polytechnic Yaba citation provided, the court held that an employee can sue for unlawful or unjustified suspension where the suspension is malified, unfair, vindictive, a clear case of victimization, and such a suspension, aside from being unlawful, will amount to being an unfair labor practice, end quote. This has not been shown to be the case in this instance suit. Accordingly, I find no merit in reliefs A, B, C, and D, and then they're all dismissed accordingly. Coming to relief E, the claimant is insistent that the employment ended with his resignation via a resignation letter written by his lawyer to the defendant dated the 25th of October. Now, the law is that an employer does not have the right to reject a resignation. Finding otherwise would be forced or slave labor. The employment relationship effectively came to an end upon receipt of the resignation letter by the defendant, subject to fulfillment of notice stipulations . Finding otherwise would be forced or slave labor. The employment relationship effectively came to an end upon resignation, receipt of the resignation letter by the defendant, subject to the fulfillment of notice stipulations, where, if not adhered to, entitle the aggrieved party to damages payable for the notice period. See the case of Yusuf as the governor of Edo State citation provided. This because there's absolute power to resign and no discretion to refuse or accept, and it's not necessary for the person to whom the notice of resignation is addressed to reply that the resignation has been accepted. See also the case of Wyek for Oshinebo citation provided. It therefore follows that the claimant, having resigned, cannot be dismissed. See the case of Jumbo versus PEFMB citation provided, where the Supreme Court held that it is elementary that an employee cannot be dismissed from an employment that has ceased to exist. I find that this applies in this instant case. The dismissal of the claimant was of no effect whatsoever. The employment contract having come to an end before the said dismissal and so hold. Now, there are different consequences for the resignation of an employer and dismissal of an employee. An employee can claim his terminal benefits when not dismissed. However, an employee that is dismissed, that puts an end to whatever entitlements he or she may have had a right to, with the exception of already earned emoluments prior to the dismissal. The benefits accruable to an employee that resigns need to be proven. The question here is, has the claimant proven entitlement to the arrest of salary? Exhibit 3 was clear, stating that suspension was not paid. The claimant now claims the salary and other entitlements for the period of suspension without pay. This was hinged on the success of the relief seeking to declare the claimant's suspension null and void, but that relief has been dismissed. It therefore follows that this relief must suffer the same fate. During the suspension period, there was no work done or no pay earned. See the concurrent judgment of DK JSC in the case of Bernard Longi and First Bank citation provided, where his lordship held thus that suspension is usually a prelude to dismissal from an employment. It's a state of affairs which exists while there's a contract in force between the employer and the employee, but while there is neither work being done in the pursuance of it, nor remuneration being paid, end quote. Leaves E, F, and I are all hereby refused and dismissed accordingly. For with J, K, and I, there's nothing before this court to show an entitlement to or proof of any of this relief, and therefore do not hesitate to refuse and dismiss relief J, K, and I for being unproven. On the whole, and for the avoidance of that, claimant case hereby feels in its entirety and is hereby dismissed accordingly. Judgment is entered accordingly, and parties are to bear their respective costs. Finally, now for Bola Joko Idigbe versus Altair Nigeria Limited and Chief Adebi Olafisoye.
Good afternoon, my lord.
Afternoon.
S.A. Nwabweze for the claimant.
S.A. Nwabweze.
As a copy, my learned friend
Yes.
Tanimola Oyekon
Yes.
appears with me. Yes, my lord.
Yes. Mr. Moses Ologu is
Yes. With proper respect to this honorable court, Moses Ologu for the defendants.
This is the constitution. The claimant commenced this suit on the 29th of April 2015, and by an amended statement of fact filed on the 20th of January 2016, the claimant seeks the following reliefs against the defendants. One, a declaration that the claimant is the beneficial owner / holder of the 3% of the shares of the first defendant company, and consequent on one above, an order of equitable relief by way of specific performance compelling defendants to register their aforesaid shares at the Corporate Affairs Commission Abuja in the alternative to two above, A and B above, an order seeking an inquiry of 3% shares of the company, the first defendant, in the second defendant, and paying same to the claimant, and B. Sorry, gentlemen, my internet connection is a bit sketchy. Can you hear me now? Yes.
You understand, my lord?
Yes. So I've made out the relief sorts. That is why the court skipped all the other reading out all the submissions of counsel in the previous decisions. Now I've summarized the relief sort here, right? The proceedings at trial, the submissions of the defendant in final address. Challenge admissibility of various documents here. Submissions of claimant in final address. And this is the court's decision. I've carefully considered the submissions of counsel and positive file in this suit. I'll start off with a resolution of the criminal objection raised by the learned counsel to the defendant in its final address. Counsel argued that the claimant had abandoned her pleadings as she had failed to give evidence to the facts and relief sought here. Secondly, counsel contends that the amended relief sought here are overreaching, having seen the pleadings, evidence, and the final address of the defendant. Finally, counsel submitted that the procedure adopted by the claimant in prosecuting this suit was an abuse of the court's process. I've gone through the claimant's final address time and again. It appears that the learned counsel to the claimant did not find the above criminal objection worthy of response. Page 2 of the claimant's final address starts with the replies to the issues raised by the defendant in his final address. The above issues were not responded to. The court would, however, look at the merits or otherwise of these objections. It is without doubt that prior to the circumstance that led to the substitution of the claimant, the deceased claimant had already testified and tendered documents which form the claimant's exhibits into evidence. Now, the present claimant replaced the deceased claimant due to the aforementioned circumstances. This also entailed an amendment to the pleadings of the claimant. However, this present claimant did not testify in support of the amended pleadings. All that is before the court is the testimony of the deceased claimant, which predates the extant amended pleadings. Pleadings do not speak for themselves. This much is right. And there was a purpose for the amendment that brought in the extant pleadings. It therefore means that whatever pleadings that were not supported by the position of the deceased claimant, which are adopted in open court, would be deemed abandoned and so whole. This, however, does not mean the wholesale abandonment of the entirety of the pleading of the claimant as submitted by the defendant counsel. The abandonment of pleadings is restricted to the unsupported evidence as contained in the CW's deposition and so whole. The defendant counsel to defendant by his contention that the amendment of 24th of May 2022 was overreaching the defendant and that the procedure adopted by the claimant was an abuse of the court process is simply inviting the court to revisit its ruling of 24th of May 2022, which granted the application for leave to amend the claimant's processes. At the hearing of 24/5/22, the defendant counsel to the defendant was in court and informed the court that he had no objection to the grant of the application for amendment. It was at this point that, having been served with the application for amendment, the defendant should have realized that the amendment will overreach it, not to bring it up belatedly in his final address, and therefore find no merit on this ground of objection, and further that find that there is no abuse of the court process. The prior objection is hereby overruled. The defendant also raised the point that the second defendant was acting as an agent of the disposed principal, and accordingly, there's no cause of action against the defendant, second defendant, and neither can he be held liable for any actions done in that capacity. Now, in the case of FBN, was Excel Plus Industries Limited, citation provided, the Court of Appeal referred to the case of Ashafa Food as Algrain, where the Supreme Court stated that the fact that a person is an agent and is known to do so does not by itself necessarily prevent him from incurring personal liability. Whether he does so is to be determined by the nature and terms of the contract and the surrounding circumstances. Where he contracts on behalf of a foreign principal, there's a presumption that he's incurring a personal liability unless a contrary intention appears. In that case, the Supreme Court, par OY for JSC, adopted with approval the opinion of Lord Seaman in Henley Yongkai versus Hong Kong and Shanghai Banking Corporation, where it was observed that it's not the law that if a principal is liable, this agent cannot be. The true principle of the law is that the person is liable for his engagement as per his thoughts, even though his action for another, unless he can show by the law of agency he is to be held that he is to be held to have expressly or impliedly negative his personal liability. Unquote. Now, it is not in contention between the parties that the second defendant acted at all material times in this suit as an agent of the first defendant. The first defendant is an artificial personality that can only act to a natural person, and indeed acted in this situation through the second defendant. Applying the above principles to the case at hand, it is the considered opinion of this court that the second defendant was properly joined as co-defendant in this suit. Whatever grievances between the parties will best be resolved with the presence of the second defendant in this suit and as a whole. I'm also in agreement that the learned counsel with the claimant that the case of Omega Bank vs OBC Limited, citation provided, applies here. In certain circumstances, like in this case, the documents can be admitted in the absence of a maker so long as the court is satisfied that the document is relevant alongside the other ancillary considerations as prescribed by the Benin Act. The minutes of the meeting in question here are relevant and thus properly admitted. Probative value will be ascribed to in the course of this decision and so on. Which brings me to the question of whether or not this court has the jurisdiction to entertain leaves that pertain to 3% of defendant shares here. The claimant contends that the declaratory leaves of the claimant is ancillary to the substratum where he possesses that. Which he possesses is the constructive dismissal of the claimant. I've carefully looked at the reliefs here. Evidence led and the context within which the dispute between the parties was ventilated before this court. I find it extremely difficult to accept that the reliefs as regard the shares of the defendant is ancillary to reliefs for constructive dismissal. In this court's considered opinion, the claimant's main grounds here is tied to his alleged entitlement to say 3% shares of the defendant company and not the other way around. The relief for the constructive dismissal came in as an alternative relief. It cannot be construed as the main fulcrum of this suit and as a whole. This being the case, the question that naturally follows, does this court have the jurisdiction over the issue of allotment and ownership of shares? I think not. No matter the ingenious arguments of the counsel to the claimant, ownership of shares in a company do not fall within the purview of labor and employment matters contemplated by Section 254C of the 1999 Constitution of the Federal Republic of Nigeria as amended. The terms connected to and relating to as contained in this section does not give allowances for the usurpation of the jurisdiction of other courts. Similarly, the phrase notwithstanding cannot be interpreted in a way that would lead to absurdity in the law. The National Industrial Court's jurisdiction is clearly delineated. The issue of ownership of shares does not form part of this court's jurisdiction. jurisdiction over reliefs 1 and all the sub-reliefs 2 and all the sub-reliefs, reliefs 2 and 3, they are all hereby struck out for lack of jurisdiction. For relief 4, it is elementary that he who asserts must prove. What here is the proof of the claimant being appointed an executive director of first defendant? This brings me to the means of meeting admission in the course of trial. While admissible, it has no probative value as it is an unsigned document of dubious origin. A claim cannot be founded on an unsigned document. Again, I'm in complete agreement with legal counsel defendant that the curious appellation of prospective directors is not only strange but unknown to law. Anyone is a prospective director of any company except those explicitly barred by law. Does it mean that any such of individuals cannot make decisions on behalf of a company without being full-fledged directors properly appointed? I think not. The claimant has not placed any evidence of value to show he was appointed as executive director as so whole. I must therefore reduce 4 Roman numeral 1 and it's hereby dismissed. Relief 4 Roman numeral 2 is in the alternative Roman numeral 1 and is also quite murky, while the facts and narrate the constructive dismissal. The claimant was appointed a pilot. He was referred to as a pilot. How was that constructive dismissal? He sought for permission to take his leave and then proceeded to abscond without reason on dealing with any of the perceived grouses. On the balance of probability, this claimant has not presented believable or convincing evidence of the alleged circumstances of constructive dismissal. I therefore refuse and dismiss relief 4 Roman numeral 2. On the whole, and for the avoidance of doubt, the claimant case fails in its entirety and is hereby dismissed. Parties are to bear the respective course. Judgment is entered accordingly. Thank you, gentlemen. I'll pick up everything on Wednesday in Lagos.
As it pleases.
Thank you.
Thank you, Your Lordship.
Thank you, Your Lordship.